Okay, so magandang hapon on a Sunday. I hope we're all doing okay. Wait lang let me set up lang muna my video. There you go. All right. So, for this afternoon, I was summoned today to discuss to you the law on contracts on a 2-hour webinar. Sana kayanin natin, no? Because law on contracts alone would account for 10 questions based on the current syllabus and TOS of the Board of Accountancy. So hopefully we can make it as comprehensive as possible given the very short time or limited time that we have to discuss this. So shout out dyan sa mga taga NFJP. I'm very sorry for last week. I was really sick. I was under the weather. Parang mamamatay na ako last week. But I am up and at 'em now. So I'm recovered and I'm on the pink of health. And yeah, so we would like to thank also Rio for having this webinar. Ongoing pa ang ating enrollment for October 2021 board exam and open na rin ang ating enrollment for the May 2022 exam. All right. So the law on contracts taken together with obligations would account for 3 units based on your undergrad of BS Accountancy. In the board exam, this would account for 10 points or 10 questions based on the current TOS of the BOA. For October 2022, when we have the revised syllabus, law on contracts would account for 6 questions na lang. No, ngayon, 10 questions pa siya next year. No, magiging 6 questions na lang. So first, how do we define a contract? Now, a contract under Article 1305 of the Civil Code of the Philippines is a meeting of minds between 2 persons whereby one binds himself with respect to other to give something or to render some service. With this very definition, there are already 3 criticisms that you will find in some civil law books, particularly yung mga experts na tinatawag nating civilists. Okay? So the first is that it accounts for something we call to give something or to render some service, which connotes that an obligation not to do cannot be included in a contract, which is not necessarily accurate. No? Because we have what you call deeds of limitations kapag ikaw ay bumili kunwari ng kondo or bumili ka ng bahay sa isang subdivision where there are certain restrictions on what you can do with your house. No? Or for example, a Honda car, kapag ikaw ay bumili, there is a prohibition to use the car for public utility, no? Which is like a taxi cab. That's why hindi accurate sa definition yung part na to give something or to render some service because obligations not to do may also be covered by a contract. Second, nakalagay na whereby one binds himself with respect to another on the proposition that obligations arising from contract are always unilateral, which is not necessarily the case. In fact, most contracts would actually provide for bilateral obligations of the parties. Third, nakalagay it's a contract between 2 persons, no? Meeting of the minds between 2 persons, which does not accurately take into account what we call auto contracts. There are what we call auto contracts which are valid, whereby one person would provide consent in 2 capacities. No? So for example, a principal may ask an agent to borrow money or authorize an agent to borrow money, and the agent himself may become the lender. So in this case, the contract of loan, the agent will be the one giving consent in behalf of himself or in behalf of himself as the lender, and he will also give consent in behalf of the principal as the borrower. So in that case, no, there is only one person who gives consent in 2 capacities. Kaya nga hindi rin accurate yung word na 2 persons na makikita natin sa definition ng contract because an auto contract may be valid, no, except yung auto contracts that you will find under Article 1491, which lists contracts, auto contracts which are void in character under the law on sales. Ayan. So yan ang ating definition ng contracts in general. So there are 3 stages in the life of a contract which will begin with what we call negotiation. As the name suggests, this is the stage where the parties are progressing with the negotiations as to what will be the terms and conditions of the contract. And this is where the rules concerning offers And acceptance will be discussed, no, as we will provide later. There are some authors who would call this preparasyon or conception or generasyon. So kailangan lang familiar tayo with the other terms that may be used kasi baka yan ang gamitin pagdating sa board exam. The second stage of the contract is when there is a meeting of the minds already on the part of the parties, which we will call perfection or birth. At this stage, the offer and the acceptance have already been provided and the parties have already come to a definite agreement with regards the essential elements of a contract. So ibig sabihin at this stage, meron ng consent with regards the object and with regards the cost or consideration. But of course, we have to take into account that there are contracts which would require other essential elements like the form, kung ito ay formal contract or solemn contract, or the delivery when we talk about real contracts that we will expound on a little later. And lastly, when the obligations under the contract have already been performed, then we call it the stage of consummation, death or termination of the contract already. So this will be the three stages in the life of a contract. And now we have elements of a contract. We can actually divide them into three, no, depending on to which they relate to. Essential elements are those which would be required for purposes of perfection. No? Ito yung mga kaya essential ang tawag natin because the absence of one of them will make the contract void. As we will discuss later when we get to defective contracts, most are actually all, no? All of the void contracts listed under the law relates to any one of the three essential elements in order to constitute a valid contract. But as we have mentioned earlier, for those which we call formal or solemn contracts, the form would be a fourth essential element. And with regards other contracts which would require delivery, real contracts naman ang tawag natin. So apat din ang kanilang magiging essential element. On the other hand, we have what you call natural elements or those which are part of the contract even if the parties have not stipulated to them. The law itself attaches this element to the contract. So for example, will be your implied warranties like warranty against eviction in a contract of sale or the warranty against hidden defects. Because despite the absence of stipulation, it is deemed included already in the contract because it is a natural element of entering into such type of contract. And lastly, we have what you call accidental elements, which exist only because the parties have stipulated to them. Otherwise stated, if the parties did not stipulate, this element would not exist. So a good example here will be the liability to pay interest, which is required to be stipulated in writing in order to validly attach to the contract. So, we'll focus first on the essential elements of a contract. As we have mentioned already, the generic essential elements of any contract will be consent of the contracting parties, the object, certain, which is the subject matter of the contract, and the cause or consideration. So, without any or may mawala lang na isa sa tatlong ito, wala nang existing valid contract. No? Yun nga lang, meron pa tayo pang-apat with regards other types of contract that we will expound on later. So we'll focus first with consent of the contracting parties. Dito kasi medyo mahaba-haba and marami ang ating mga rules. No? So consent will be manifested by the meeting of the offer and the acceptance of the other party concerning the thing, which is the subject matter of the contract, and the cost or consideration. So consent must relate to the two other essential elements in order to validly form a contract. So, in offer and acceptance, the offer must be certain. No? Kailangan certain ang terms na walang pagdududa on the part of the offeree kung ano talaga ang terms ng offer. On the other hand, the acceptance must be absolute. Because if the acceptance is what we call qualified, it would only be considered as a counter offer. No, magiging counter offer lang. In short, wala pang magiging meeting of the minds. So if for example, itong CS, binibenta ang kanyang lupa, sabi niya kay B, binibenta ko yung lupa ko for 10 million pesos. Sabi ni B, sige, tatanggapin ko yan. Bibiling ko na yung lupa mo, pero bibiling ko yan for 8 million pesos lamang. So in this case, while there is an offer on the part of S to sell the property for 10 million, but the acceptance of B is qualified as to the price or the cost or consideration of the contract, then there is no meeting of the minds yet. No, what B provided to S is merely a counter offer, at kung tanggapin niya ni S, doon lang tayo magkakaroon ng meeting of the minds. The acceptance can be expressed or implied, and the person making the offer may likewise provide the terms of the acceptance, including the time, place, and the manner by which acceptance must be provided. And when the offerer actually provides those terms in relation to the acceptance, then they must be complied with in order for there to be meeting of the minds between the parties. Now, there are two schools of thought with regards the perfection of a contract, and one of which is what we call the cognition theory, where the perfection of the contract happens at the time the offerer knew or has knowledge of the acceptance by the offeree, not when the time the offeree manifests his acceptance of the offer, which is the other school of thought, which we call the manifestation theory. Dito sa Pilipinas, ang sinusunod natin ay yung cognition theory. Now, because as provided in Article 1319, whenever the acceptance will be provided by letter or telegram, the perfection will happen only at the time the offerer knew or the acceptance came to the offerer's knowledge. No? Kaya clearly under the Civil Code, we follow what we call the cognition theory. So to give an illustration para lang ma-visualize natin ito, no? So if for example, on January 1, the offerer sent the letter offer, natanggap yung letter offer na yan on January 5, January 8, nag-send si offeree ng acceptance letter, pero January 15 pa na-receive ng offer. In this case, the meeting of the minds will happen on January 15 when the offerer had knowledge or knew of the acceptance by the offeree. No, hindi kung ka-manifestation theory sana ang ating sinusunod, then the contract would have been perfected on January 8, no, when the offeree sent an acceptance letter. But since we follow the cognition theory, perfection of the contract in this case will happen on January 15 only. Ito yung medyo significant na naging effect ng e-commerce law, which incidentally is also covered by the CPA licensure exam, no? Kasi sa e-commerce law, it provides for the rules on time and of dispatch and receipt, no? So yan yung medyo naapektuhan with regards the premise of the cognition theory in the perfection of a contract. All right, now it is also important to note exactly when a contract will be perfected, which as we have mentioned will be at the time when the offeree or offerer rather had knowledge of the acceptance by the offeree, because there are what we call intervening events. And under this provision of the law, whenever death, civil interdiction, insanity, or insolvency of either party before the acceptance is conveyed or known to the offerer, then the offer becomes ineffective automatically or by operation of law. So in our illustration earlier, January 8 pinadala yung acceptance, January 15 natanggap. But if on January 10, which is an in-between, meaning after napadala yung acceptance, pero before pa ma-receive yung acceptance on the part of the offerer, namatay, no, yung offerer, or nagkaroon ng civil interdiction, insanity, or insolvency, the offer becomes ineffective, which means that there will no longer be a perfected contract because there is no longer an effective offer at the time the acceptance was made known to the offerer. So nagmamatter lang as to whether we have a perfected contract or not. Now, another illustration, paano kung kunwari hindi naman siya death, civil interdiction, insanity, or insolvency, but a mere withdrawal? No, ibig sabihin, the offerer withdrew the offer bago pa makuha or ma-receive yung acceptance, pero napadala na yung acceptance letter. So sabi natin January 8 pinadala yung acceptance, but for example, January 12, ayan, after the acceptance letter was sent but before receipt, nagkaroon na ng withdrawal. Okay, so the offerer sent a letter withdrawing the offer, and January 15 na-receive yung acceptance, na-receive ang acceptance ni offerer, pero 16 pa na-receive ni offeree ang withdrawal. So in this case, is there a perfected contract? Yes, no? or no rather, will be our answer. In the same manner that death, civil interdiction, insanity, or insolvency will make the offer ineffective by operation of law, then on January 12, supposedly ineffective na rin ang offer despite the fact na hindi pa nare-receive ng offeree yung letter of withdrawal. No? Kasi dapat pareho ang magiging rule natin with regards to the intervening events. So, ibig sabihin, what we're trying to say is that the withdrawal does not need the knowledge of the offeree para maging effective yung withdrawal. It becomes effective the moment the offerer decides to withdraw the offer. Okay? Similar with death, civil interdiction, insanity, and insolvency. So I hope we're clear with that. Again, significantly affected ito by e-commerce law kasi ngayon text message na lang or email na lang, mas mabilis na. No? Hindi katulad ng mga by mail dati or by telegram, may mga days in between pa that happens. No? Kaya yan lang ang medyo significant amendment kasi oras-oras na lang ngayon ang nagiging difference when we talk about the cognition theory applying the provisions of the e-commerce law. Now, on an option agreement, in this case, there is an offerer who allows a certain period of time, but the period provided to the offeree will be whether or not to accept the offer, not to perform the obligation. Although most of the questions that you will encounter in the board exam related to option agreement will actually relate to the law on sales. But nevertheless, once there is an option agreement, ibig sabihin there is no separate consideration. There is no separate consideration for the period provided by the offerer. It is an option agreement and it can be withdrawn at any time without being liable for damages. No, walang magiging liability for damages si offerer kahit i-withdraw pa niya kahit hindi pa tapos ang period. So if for example, sabi ni S kay B, binibenta ko ang lupa ko for 10 million pesos. Bibigyan kita ng 30 days, mag-isip-isip ka kung bibilin mo ba yung lupa or hindi. No? So in this case, since there is no separate consideration for the period provided whether or not to accept the offer, kahit mag-withdraw si S on the 10th day, on the 15th, on the 20th, hindi siya magiging liable for damages. And the withdrawal will likewise be valid. Pero kung kunwari, nagbigay si B dito ng 2,000 pesos as option money, no, precisely to secure the 30-day period within which to decide to accept the offer or not, then in this case, hindi pwedeng basta-basta mag-withdraw si S. Pwede siyang mag-withdraw, pero if he withdrew within the 30-day period or before the expiration of the 30-day period, then he will be liable for breach of the option contract. Now, because there is a separate consideration for the period to decide, we call it an option contract. And if S withdrew before the period provided as already, or before it expires, the period provided expires, then he will be liable for damages on the account of his breach of the option contract. Nevertheless, in both instances, whether you call it an option contract or an option agreement, once there is acceptance on the part of the offeree, there is already a perfected contract and no withdrawal can be made anymore. No? Kapag nagkaroon ng acceptance before the withdrawal. Okay, yan lang ang medyo twist na nai-encounter natin pagdating sa board exam. Alright, how about advertisements? Under the Civil Code, as a general rule, an advertisement is not a definite offer, except when it appears otherwise. So, depende sa tono ng advertisement. No? Advertisements are generally regarded only as invitations for bidders to make their proposal, and for the advertiser, it is not, or the advertiser is not yet bound to accept the highest or the lowest bidder. Again, unless there is a separate or different tenor to the advertisement itself. In the Book of Justice Paras, nagbigay siya ng ganitong example. Sabi niya, kung kunwari yan, nagbibenta ng lupa, tapos di ba nakikita natin merong mga nakapaskil na ganyan sa lupa mismo. So if nakalagay is for sale 1,000 square meter lot for 1 million pesos, in this case, the advertisement is already a definite offer because it already contains the object of the contract, which is the 1,000 square meter lot, and the cost or consideration necessary, which is the price of a definite amount of 1 million pesos. Kaya kung merong lumapit kay X at sinabing bibiling ko na yung lupa na 1,000 square meter lot for 1 million pesos, there is a perfected contract already because the advertisement itself constitutes the offer. Pero kung kunwari, ang nakalagay lang dun sa paskil or sa advertisement is for sale 1,000 square meter lot, 1 million to 1.2 million pesos. In this case, it is not yet a definite offer because there is no definite cost or consideration to consider. No? Kaya in this case, it will merely constitute an invitation on the part of the advertiser for the others to make a bid. No? But he will not be bound to accept the highest bidder unless, again, the contrary would appear. Now, there are 5 situations concerning consent or maapektuhan yung rules natin concerning consent. In fact, dito na rin natin malalaman minsan yung status ng kontrata because of the status or the situation concerning the consent. The first situation will be both parties gave their consent with regards to the essential elements of the contract. Dito wala tayong problema. The contract is perfectly valid because the parties have already provided their consent concerning the object and the cost or consideration. Second situation, Second situation will be if there is simulation on the part of any of the parties. Simulation can either be absolute whenever there is no actual intention to be bound by the contract, in which case the contract will be regarded as a void contract for the absence of the essential element of consent. No? So for example, sabi lang A and B jokingly or in jest, yan minsan ang ginagamit na term kung bar exam, no? In jest entered into a contract of sale. So since in the between A and B there's no actual intention to be bound by a contract of sale, then there is no contract of sale to speak of. No? It will be a void contract because they really have no intention to enter into a contract. On the other hand, we have what you call relative simulation. In this case, the parties actually agree to a different intention. Okay? But they make it appear otherwise. So if for example, A and B again entered into a deed of sale, pero ang nilagay nilang presyo ay 1 peso. So pinagmumukha lang nilang sale, but the actual intention is donation. In this case, it is not entirely void because the parties will be bound by their original intention. Hindi katulad sa absolute simulation, wala talagang kontrata, no? Kaya walang or iyan ang magiging part ng ating void contracts as we will discuss later on. Kasi nga, non-existing yung element of consent, which is an essential element for purposes of perfection. The third situation concerning consent will be when one party is incapacitated. When we talk about incapacity, we'll have to clarify first whether the incapacity is related to juridical capacity, which is the fitness to be subject of legal relations that is inherent in every natural person and will be lost only through death. In layman's terms, juridical capacity relates to your legal existence or yung pag-exist mo in the eyes of the law. No? But if incapacity relates to juridical capacity, the contract will be regarded as void kasi non-existing yung other party in the eyes of the law. So if, for example, corporations, as a general rule, a corporation acquires juridical personality from the moment it is issued a certificate of registration. Kaya kung kunwari, ikaw ay makikipag-transact sa isang corporation na hindi registered or walang COR, then the contract generally will be regarded as void dahil non-existing ang iyong contracting party. Kasi nga, kailangan yung juridical capacity to legally exist or to be subject of any legal relation. On the other hand, if the capacity relates to what we call legal capacity or capacity to act, then depende. As we will discuss in a while. But capacity to act will be the power to do acts with legal effects, which may be acquired and eventually may be lost. So for example, minors does not have any capacity to act. Pag nakarating sila ng 18 years of age, age of majority, magkakaroon na sila ng capacity to act or legal capacity. Na? Or kung kunwari, ikaw naman ay age of majority na, but you suffer the penalty of civil interdiction, then again, mawawala ang iyong capacity to act or legal capacity. Kaya nga pwedeng i-acquire, pero ding mawala ang capacity to act. No? But the premise of capacity to act is that you have juridical capacity. No? Yun nga lang, you cannot generally enter into contracts with other people because of your lack of legal capacity. Now, to expound on that, legal capacity or capacity to act may either be absolute, in which case you are prohibited or not authorized to give consent in any type of contract. No? So, dito papasok yung ating mga minors, insane, deaf mute, so that do not know how to read and write. Dito rin papasok yung mga kasama ng sa rules of court that will require guardianship, such as imbeciles or those suffering from civil interdiction. So we call it absolute because it will be on any type of contract and in whatever capacity. No? Hindi sila pwedeng magbigay ng consent, or they are not allowed, or they cannot validly give consent, no, because of their absolute incapacity. Save for essentials with regards minors, no, kasi pag essentials ina-allow under the civil code on the law on sales whenever they buy or for purposes of purchase of essentials. Now, on the other hand, we have what you call relative incapacity. As the name suggests, yung incapacity nila depende, no? It can either be that they are not allowed to enter into specific types of contract, or they cannot enter into contracts in a certain capacity. So if, for example, like husband and wife, no? A husband and wife are people. Okay, so H and W, for example. H and W may enter into contracts with other people. Si H can enter into a contract of sale. Si W can enter into a contract of lease. But they cannot enter into a contract of sale with each other. Okay, kaya nagiging relative ang incapacity because they are incapacitated to enter into a contract of sale only as to each other. Ganon din sa Article 4091. For example, yung guardian, hindi niya pwedeng bilhin yung property ng ward, or yung administrator, executor ng estate, hindi niya pwedeng bilhin yung property under his administration. So relative lang in capacity with that particular contract. No? Or aliens under the Constitution, which are prohibited to acquire land. So again, the incapacity is relative only as to land and only as to acquiring it, except by succession. No? So kaya relative kasi depende sa kontrata na pinapasok and depende rin sa capacity by which they are entering the contract. Kaya hindi katulad ng absolute, kahit anong klase ng kontrata generally hindi pwede, no, because they cannot validly give consent. Now, the fourth situation will be when both parties are incapacitated pertaining to legal capacity. So kung kunwari minor yung isa insane, they entered into a contract, the contract will be regarded as unenforceable. This is the third type of unenforceable contract that we will expound on a little later. And yung fifth will be if both parties gave their consent but the consent is vitiated, no, by any of the five vices of consent. And yan naman ang ating i-discuss in relation to our first essential element, which is consent. The vices of consent can be either be mistake, violence, intimidation, undue influence, or fraud. Para hindi kayo masyadong mahirapang tandaan ang magiging epekto ng mga ito, no, ng mga vices of consent, mistake, and fraud. Dali, ayusin natin. Yeah. Mistake and fraud will pertain to intelligence in giving consent. Naapektuhan yung intelligence in giving consent. Violence, intimidation, and undue influence will relate to voluntariness. No? Because the consent was not voluntarily given because of the vice of consent provided. So yan ang medyo magiging points of reference natin with regards to the effects of any of these five vices of consent. So first, mistake. Mistake must relate to fact. Now, there can be no mistake of law that will affect a contract because of the presumption under the law that all people are aware of the law. No, yung ignorance of the law excuses no one from compliance therewith. So the mistake must either relate to the object of the contract or to the conditions that principally move the parties to enter into such contract. But they must relate to a mistake of fact, not mistake of law. Now, mistake will make the contract voidable if it relates to number one, the principal object. So if for example, bibili ng gold-plated watch or bibili ng gold watch, supposedly ang intention niya pero ang binenta pala sa kanya ay gold-plated watch, in which case that can be a mistake that will make the contract voidable. Or it relates to the principal conditions such as the area of the land. No, when there is already a plan intended for the area, or stated otherwise, kung ikaw ang buyer, you would not have entered into the contract knowing of the shortage with regards to the area of what you are purchasing. Third, with regards to the identity or qualifications of the parties, particularly if those qualifications were considered in constituting the contract, being the principal causes therefore. So kung kunwari mag-hire ka na mag-speech sa graduation, mag-hire ka ng kakanta sa birthday mo, no? Or reviewers in a review school, tapos they turned out to be not qualified that you have originally intended, then you may make that will make the contract voidable, which may or rather goes into mistake of fact, no? But when we talk about qualification of the parties to the contract. And fourth, when regards to legal effect, take note, this is not a mistake of law. If there is a mistake as to the legal effect of the actions of the parties which frustrates the agreement, and there is mistake on both of them. So if for example, si S dineliver ang car niya kay B at si B naman nagbigay ng pera kay S. Akala ni S ang contract nila ay loan that is secured by a pledge over the car. On the part of B, akala naman niya pacto de retro sale ang kanilang pinapasok, or a sale with the right of repurchase. So dito, there is one action for both parties. May pag-deliver ng car, may pagbayad ng pera, but there is mistake with regards to the legal effects of what they are doing. No? Kaya it may make the contract voidable as well on the ground of mistake. Now, second will be violence. When in order to wrest consent, there is serious or irresistible force that is being employed on one party, which again affects voluntariness. No? Kaya lang siya pumasok sa kontrata ay dahil ginugulpe. No? So dito talaga pisikalan when we talk about violence. As opposed to what we call intimidation, which is more of sa isip. No? Threat pa lang ito on the part of the party. There is imminent or grave evil that will be inflicted upon the person of the party, his property, or upon the person or property of his relatives, such as the spouse, descendants, or ascendants. Kaya niya binigay ang kanyang consent. Ngayon, ang nagiging isang issue dito that is being raised by other people, ibig bang sabihin, sir, kung kunwari, the violence, kasi yan ang mismong provision for intimidation, for violence, ito lang mismo ang nakasulat. So, sir, paano kung ang ginugulpi po ay asawa, kapatid, lolo, lola, anak, tatay, nanay? Ibig bang sabihin, it will not vitiate consent kasi hindi katulad sa intimidation, ni-relate talaga sa spouses, descendants or ascendants. Pero sa violence, walang ganong equivalent. Not necessarily. No? I would take the position that the violence inflicted upon your relatives may still vitiate consent because they both affect voluntariness. That the only reason why you would enter into the contract is because of the violence inflicted upon your relatives. No? Na, kaya kahit wala sa provision pertaining to violence, it is still a valid ground to invoke that the contract is voidable for the vitiation of consent because of violence. Kasi nga, on both instances, walang voluntariness in giving the consent. So, to determine the degree of intimidation, the factors that may be considered will include the age, the sex, and condition of the person. But take note, in this case, an exemption or an exception in intimidation will be whenever it is grounded upon a claim that may be enforced through a competent authority, in which case there will be no intimidation that will vitiate consent. So if, for example, may rape victim, no? Tapos sabi niya doon sa rapist niya, kapag ako hindi mo pinakasalan, papakulong kita. So kinasal sila, pwede bang sabihin ng rapist na vitiated ng consent niya in the wedding or in giving his consent in the marriage? No, because the claim or the threat coming from the victim is founded on a claim that is enforceable through a competent authority. Kaya walang magiging concept doon ng intimidation. No? Kapag based on a claim which can be enforced through competent authority. Now, undue influence on the other hand, ito yung merong influence literally, no? Na influensyahan ka. In this case, there is a person who takes advantage of his power over the will of another, depriving him the reasonable freedom of choice. So again, voluntariness ang naaapektuhan dito. No? In taking into account whether there is undue influence, the following circumstances may be considered: confidential relationship, family, spiritual relationship, and other relationship between the parties. No? In this case, we may also consider the mental weakness or whether the other party is considered ignorant or in financial distress. Again, it all boils down to the fact that there is no voluntariness on the part of the other party in giving his consent. And lastly, we have what you call fraud. Fraud in this case is what we call causal fraud, no? Because here there are insidious words or machinations that are employed by one party to induce the other to enter into a contract. Ang premise is that kung wala sana yung insidious words or machinations na yan, hindi papasok sa kontrata yung other party. No, that's why we call this causal fraud as a vice of consent, as opposed to incidental fraud, which does not affect the validity of the contract because it is employed in the performance of the obligation na, which may give rise to damages, but it will not make the contract voidable. So there is no fraud in the following cases. Number one, when there is failure to disclose facts, when there is no duty to reveal them. If there is a duty to reveal them and you did not disclose the facts, that is technically concealment, which also will be considered fraudulent. Now, when there is a duty to reveal them. So for example, dyan yung insurance. Kung ikaw ay nag-a-apply ng insurance, tinatanong, ikaw ba kailan ka huling na ospital? No, those are required to be disclosed. And if you do not disclose them, they will constitute concealment that make the contract voidable on the part of the insurance company. The usual exaggerations in trade will not constitute fraud, especially if the other party had an opportunity to know the facts. The law acknowledges, no, that the sellers may be exaggerating their products. Yan, to take into account kung kunwari law on sales. Talagang meron at meron naman talagang magpapa-OA ng kanilang mga tinitinda. Third, will be a mere expression of opinion, as a general rule does not constitute fraud as well, except if the opinion is provided by an expert and the other party relied on such opinion because the expert had a special knowledge on the subject matter. No? In which case, if both elements are present, then it will constitute fraud that will make the contract voidable. Wala rin tayong fraud if the misrepresentation is being done by a third party, but if it creates a substantial mistake and the same is mutual, it may still make the contract voidable but on the ground of mistake already. Still walang fraud. No? Wala rin tayong fraud if the misrepresentation was made in good faith, but again, it may still make the contract voidable on the ground of mistake or error, no? But not necessarily fraud. So those are the 5 vices of consent which will make the contract voidable. And our second essential element, aside from consent, will be the object certain. The object certain, which is the subject matter of the contract, can either be things, rights, or service. Take note, these are the 3 types of objects when we talk about contracts in general. No? Because kung kunwari, ang pinag-uusapan natin ay contract of sale specifically, things at rights lang ang pwede. There is no contract of sale concerning services. It may be a contract for a piece of work, contract of agency, or a contract of employment dahil services ang kanyang subject matter but not a contract of sale. Kaya kung tatlo na things, rights, at service, this can be objects of a contract in general. Okay? In general, not specific types of contract that are covered by the board exam separately. Ayan. Now, so the rules concerning the object in a contract. Number one is that the right thing or service must be within the commerce of man. So hindi ka pwedeng magbenta ng internal organs. But take note, this actually is relative depending on the type of contract that you're entering into. No? Kasi for example, yung body organs, hindi mo pwedeng ibenta. Okay? You cannot enter into a contract of sale because it is prohibited by law. But you may donate. Diba? In fact, i-check mo lang sa lisensya mo na pag ikaw ay na-aksidente, you authorize the removal of your organs to be donated or to be used by other people. Okay? So, but generally, the requirement is that it must be within the commerce of man. Kaya yung iba makikita mo sa Facebook, ang sweet-sweet pa nung magjowa na binilhan daw ng constellation, binilhan ng stars, binilhan ng piece of land sa moon. No, those are naglolokohan lang yan. Hindi yan totoo. Because heavenly bodies are considered outside the commerce of man being res nullius. Yan. Res nullius. Under the concept of international law, nobody owns those objects which is in the outer space. No? Kaya hindi yan pwedeng ma-subject of appropriation, hindi pwedeng mabili, hindi mo pwedeng i-donate sa ibang tao kasi walang may-ari under international law. So, hindi naman kasi kung kunwari niregaluhan naman kayo, di sweet pa rin yung idea, no? Yung nga lang legally hindi talaga siya totoo. Now, it must be transmissible and it must not be contrary to law, morals, good customs, public order, public policy. Take note itong mga rules natin kasi pag na-violate ang rules na ito, defective na kagad yung object, wala ka ng valid contract. Or otherwise stated, magfo-fall na siya sa classification natin ng void contracts. Because again, object is an essential element that is necessary for perfection and validity. It must not be impossible. In this case, the impossibility exists at the time the contract was entered into, and it must be determinate as to its kind or at least determinable without need of a new contract or agreement. Now, take note, however, that the law prohibits a contract from having a future inheritance as its subject matter. Because in this case, buhay pa ang may-ari, kaya hindi pa pwedeng maging subject ng kontrata. No? Kung kunwari ikaw ay tagapagmana, hindi mo pwedeng sabihin sa buyer na, oh, bilhin mo na tong lupa na yan. Sino bang may-ari niyan? At yung tatay ko kasi pag namatay siya, ako naman ang magiging may-ari niyan. Hindi yun pwede. No? Because it gives motivation for both parties na pabilisin ang pagpapamana. No? Kaya pinagbabawal na lang ng batas in the first place. Oh, so when the contract covers future inheritance as its subject matter or object, it is a void contract because that is contrary to law. But take note that there are two types of contracts that may validly be entered into concerning future inheritance. Number one is what we call partition inter vivos. A partition inter vivos is when the owner of the property divides it to the heirs while he is alive. Pero kasi involve yung mismong may-ari. No? At pinag-uusapan lang kung paano paghahatian, but not necessarily na kanila na mapupunta agad kahit buhay pa yung predecessor. Second is what we call a marriage settlement or more popularly known as the prenuptial agreement, because there can be provisions in a prenup or a marriage settlement agreement concerning future inheritance already between the spouses or the would-be husband and wife. And now, the third essential element is what we call cause or consideration. So, cause or consideration in each contract, if the cause or consideration will be the promise or the thing or service that will be performed by the other party, it is considered an onerous cause or consideration. On the other hand, if the cause or consideration is the mere liberality of the benefactor, that is considered gratuitous. Or if the cause or consideration is the past services that have already been rendered, then it is called a remuneratory contract. Now, you will notice now from the very definition or classification of contracts because of cause or consideration will be the reason why you are entering into a contract. So if, for example, in a contract of sale between S and B, the cost or consideration with regards the seller will be the price that will be paid by B. And on the part of B, the cost or consideration will be the transfer of ownership. with regards the object, no, of the contract of sale. So this is onerous because the cost or consideration for either party will be the prestation or promise of the other party. In a donation, kung binigyan ni donor si donee, ang dahilan lang bakit niya binibigyan is yung kanyang kagandahang loob, no, or liberality. Okay? So kung example naman, si donee pala ay yaya na matagal na ni donor tas binigyan niya ng bahay as a reward, then that is remuneratory contract. No? Because the consideration are past services that have already been rendered. Now, the rules concerning cost or consideration, number 1, contracts without cause or with a cause but the cause is unlawful will produce no effect whatsoever, which means that the contract is void. Again, it all boils down to the fact that the cause or consideration is an essential element of a contract, which means kung ito ay nawawala or illegal, then wala kang kontrata na pag-uusapan. No? Void ang magiging kontrata mo dahil nawawala yung isang essential element. The statement of a false cost will render the contract also void if it will be proven that it is not founded on another cause, which is true and lawful. Or stated otherwise, if there was another cause, which is true and lawful, despite the existence of a false cause, then it may still be a valid contract. Ang i-consider natin is the true and lawful cause. Pero kung kahit yon ay wala, then void na ang kontrata. Because again, nawawala ang isang essential element. Although cause is not stated in the contract, it will be presumed that the cause or consideration in fact exists. This translates to the idea na kapag naka-encounter din tayo ng problem type questions sa board exam at silent yung ating problem as to what is the cause or consideration, we can presume that it legally exists because the law itself attaches the presumption for its existence and the presumption that it is legal. So fourth, the rule as a general rule, the inadequacy of the price will not affect the validity of a contract. So if for example, si S nagbenta kay B ng lupa, ang fair market value ng lupa ay 1 million, pero binibenta lang niya for 200,000. As a general rule, the contract is valid despite the inadequacy of the price. In fact, pagdating nyo sa law on sales, no, nakalagay pa doon na even the gross inadequacy of the price as a general rule does not affect the validity of the contract. Kaya dito, kahit 800,000 pa ang difference niyan, as a general rule, valid ang kontrata na yan. Okay? Kasi the inadequacy of the price will not affect the contract. Of course, except if it is provided for by law. So if for example, ito palang si seller ay guardian ng isang ward at ang binibenta ni seller na lupa ay yung property ng ward. So in this case, it will be rescissible because the ward suffered lesion by more than 1/4 of the fair market value of the property. Because the law itself provides for a separate classification as a result of the inadequacy of the price. Or there were vices of consent that were inflicted by S to B, no? By fraud, mistake, or undue influence, kaya nag-agree si S na ibenta for a lesser price. In which case, the contract will be voidable. No? So, again, as a general rule, it will not affect the contract except as may be provided for by law, such as rescissible contracts, or when there are vices of consent, which are the reason why there was inadequacy of the price, in which case the contract may be voidable. Now, and lastly, motives of the parties to a contract will be different from the cause. Kaya kung itong motibo mo ay illegal, it will not necessarily affect the validity of the contract. So if for example, itong si S yan, ay nagbenta ng baril kay B. Ang motive ni B in buying the gun is in order to kill X. No? Nevertheless, the contract of sale between S and B will still be regarded as valid because as to S, the cost or consideration remains to be the price that will be paid by B, and for B, in the contract of sale, the cost or consideration remains to be the transfer of ownership concerning the gun. No? Kaya despite the existence of an illegal motive, it does not generally affect the validity of the contract kasi magkaiba ang motive natin sa cause or consideration into entering into a contract. Okay, now other essential elements that we may encounter may include form with regards formal contract or yung mga tinatawag nating solemn contract such as donation of real property, kailangan in a public instrument for validity. On the other hand, there are what we call real contracts which are perfected by delivery. Dito, kahit may consent na, may object or may consideration, hindi pa rin valid ang kontrata hanggat walang delivery. In the civil code, there are only 4 types of contracts that are considered real contracts, which are perfected by delivery. So, deposit, pledge, comodatum, and simple loan or mutuum. No, yan ang 4 na real contracts na meron tayo which will require delivery for purposes of perfection. All right? And with that, bago tayo tumuloy sa forms of contracts at dahil kasi nga 'di ba ang boring talaga ng topic pag RFBT, we will take a short break para lang makapag-stretching, mag-CR muna yung iba. We'll have a 10-minute break na starting now before we continue with forms of contracts. All right. So, sana you'll stay muna, you'll stay there no, because we still have an hour to discuss the rest of the law on contracts. All right. So, see you in a while. In 10 minutes, we'll have our 10-minute break first. Break. Okay, so going back, sana buhay na buhay pa tayong lahat no, on this afternoon na Sunday. Ayan. Ang hirap kasi yung katatapos lang mag-lunch tapos didiscuss bigla loan contracts. Anyway, so we are now on forms of contracts. As a general rule, walang form ang required ng batas. Kaya nga generally contracts are regarded as consensual in character. The meeting of the minds of the parties generally perfects the contract already. No, walang form required. But there are certain instances when the law would require a certain form. So except number 1, yan yung required yung form for purposes of validity. Yan yung mga tinatawag nating formal or solemn contracts. No? Because the form itself becomes a fourth essential element for perfection or validity. Second will be when the form is required for enforcement. Dito papasok yung tinatawag nating statute of frauds because it is required to be that the transactions are in writing in order for them to be enforceable. And the third group of formal requirements will be when the form is required to bind third persons or to affect third persons. In this case, the contracts are already valid and they may be enforceable kung in writing lang, but the law would require it to be in a public instrument in order to affect third persons. So to give illustrations dito sa formal or solemn contracts natin where the form is required for purposes of validity, papasok dito yung mga donation of real property where the donation and the acceptance must be in a public instrument for purposes of validity. Stated otherwise, kahit pa in writing ang donation mo ng real property pero hindi naka-public instrument, void ang donation because the form of public instrument here is a requirement for validity purposes. Meron din yung donation ng personal property where the value or the amount exceeds 5,000 pesos which will require the donation to be in writing. In the same vein, the acceptance must likewise be in writing for purposes of validity. Third will be if there is a stipulation to pay interest because it is required under the law in order to be liable to pay interest for the use of money, the stipulation must be in writing. And a sale of transfer of large cattle because under the cattle registration decree, kapag ikaw ay magbibenta ng large cattle, kailangan ito ay in a public instrument. The sale itself must be registered and there must be a certificate of transfer that must be issued. Yung tatlong yan are formal requisites for purposes of validity. No? Kaya dito, again, the required form will be a requirement for purposes of the contract to exist or to be validly existing. Now, on the other hand, those that will be required for purposes of enforceability is that the contract must be in writing. Kaya nga dito papasok yung tinatawag nating, in writing, kasi ito yung tinatawag nating statute of frauds. Ayan. Ito na rin yung papasok sa discussion natin mamaya ng mga unenforceable contract of the second type. So, statute of frauds lists the transactions under the law which are required to be in writing in order for them to be enforceable. There is a meeting of the minds as to the object or the consideration, but since it is prone to fraud, no, or we don't rely on the people's memory only, it is a requirement by law for them to be in writing in order to be enforceable. So there might be a contract that is existing or valid, but it is unenforceable under the law. So this will include those that will not be performed within 1 year from the making thereof. So papasok dyan kahit contract for a piece of work. Sabi mo, gagawang kita ng customized na lamesa kasi nakita ko sa Home Bodies. No? Gagawa kita ng customized na lamesa pero i-deliver ko siya sa iyo after 1 year pa. So, in order for the contract to be enforceable, it must be in writing. Or otherwise stated, kung oral lang ang kanilang naging agreement, it will be an unenforceable contract. It will also include promises to answer for the death, default, or miscarriage of another, such as a contract of guarantee, a contract of surety. So in order to be enforceable, it is required to be in writing. Third will be an agreement in consideration of marriage, except a mutual promise to marry. So kung kunwari, in one Supreme Court case, no, merong ikakasal na yung magjowa, tapos yung mga tatay nila nag-usap with regards to the construction of the house of the girl's father, no? Papagawa yung bahay nila kasi doon titira yung mag-asawa pag sila'y kinasal na. Tapos hindi natuloy yung kasal kasi nagbago ang isip ng babae. So, in that case, yung enforcement as to the damages cannot be enforced because the contract was not in writing. Pero yung mga nagastos sa kasal, yung mga down payment sa mga supplier, inallow ang recovery. Inallow ng court ang recovery because they were based on a mutual promise to marry that is not covered by the statute of frauds. Kaya nga yan, other than a mutual promise to marry. Kasama din dito will be the sale of personal property or chattels when the amount is not less than 500 pesos or stated otherwise at least 500 pesos ang presyo, no? Which is required to be in writing also in order to be enforceable. With regards sale of auction, papasok din yan dito, pero the entry in the auction book satisfies the requirement of in writing. Kaya magiging enforceable na kahit pa may entry lang sa sales book, no? Enforceable na yung sale by auction. Fifth will be an agreement for lease for longer period of 1 year and or sale of real property or an interest therein. Now, take note, ito lang yung mga peculiarities that I'll have to highlight para lang baka hindi nyo mapansin, no? Unang-una, itong provision na ito pertains only to real property. Kaya kung ang pinapaupahan or lease for a period of more than 1 year ay personal property, kahit pa yan ay oral enforceable na. No? Kasi ang covered lang ng statute of frauds as to lease for a period of more than 1 year will be real property. Kaya kung personal property ang papaupahan, kahit pa more than 1 year yan, pwede na yan kahit oral. Enforceable na din. No? With regards sale of real property, this will be regardless of the price. Now, there was one board exam question before na bumili ng lupa para patatayuan lang ng stante ng barangay, di ba? Minsan makikita mo sa mga kanto-kanto, meron yung barangay chairman, barangay kagawad, nakalista sila isa-isa. Yung portion ng lupa na yun binili for 499 pesos orally. In this case, the oral sale of the land remains to be unenforceable. Kasi regardless of the price, if the sale concerns real property, it must be in writing. Na? Kaya nga yung sinasabi na lease of car, kunwari 10,000 ito monthly. Ayan, lease of car, tas ang period ay 2 years. This is enforceable even if it is not in writing. Kasi ito, yung number 4 pertains only to a contract of sale. It will not apply to lease of personal property. And itong 5th naman, yung lease dito is for real property only. No? Kaya walang provision ng statute of fraud that will pertain to a lease of car of more than 1 year. Okay? Kaya kahit oral yung contract na yan, magiging valid and enforceable. And lastly, you have representation as to the credit of a third person. Magiging binding lamang ito if it was made in writing. So those are the transactions enumerated under the Statute of Frauds, Article 1403, if I'm not mistaken, subparagraph 2. No? In that case, it is an exclusive list. No? Kapag wala sa listahan na yan, hindi na covered ng Statute of Frauds. But the other rules on Statute of Fraud, we will discuss in a while. The last will be the form that will be required to bind third persons. Again, the contract here may already be valid and it may already be enforceable. The requirement of a public instrument by law will only be for purposes of binding or affecting third persons. So kasama dyan yung mga transactions involving real rights or immovable property. Kaya kung sale of land, kunwari, no? Sale of land ang pinag-uusapan natin and it was in private instrument or in writing, valid and enforceable na ito. No? Kasi yung requirement ng public instrument para lang to bind third persons, not necessarily for validity purposes, except if the sale of land is made through an agent, in which case the requirement of the law is that the authority of the agent must be in writing for purposes of validity. No? Otherwise stated, if the authority of the agent to sell the land is oral, kahit pa public instrument yung pagbebenta ni agent, void pa rin yun. No? Kasi dapat ang authority ng agent itself is in writing. Kasama din dito will be those involving hereditary rights, the cession, repudiation, or renunciation of the same, or the share of a spouse with regards the conjugal properties or absolute community of property for that matter. In order to affect third persons, the cession, repudiation, or renunciation must be made in a public instrument. Kasama rin with regards administration of property, to affect third persons, it must appear in a public instrument as well. And lastly, with regards rights coming from a public document, the cession of the same or yung cancellation ng rights na yan to affect third parties must also be in a public instrument. Kaya nga papasok dito yung provision ng batas natin when the other party can require the compliance with a specific form of law. But take note, in order for this right or remedy to be applicable, the contract itself must already be valid and enforceable. Stated otherwise, if the contract is void because of the non-compliance with the formal requirements of the law, you cannot use this remedy to correct that. Or if the contract falls under the statute of fraud, kaya naging unenforceable sa, hindi mo rin pwedeng gamitin ang remedy na ito para lang pilitin siyang mag-in writing to make it enforceable. No? Kaya sabi ng batas, this will be only applicable when the contract itself is already valid and enforceable, which limits its application to our third exception, which is yung requirement ng public instrument only to affect third persons. No? Doon lang mag-a-apply itong remedy na ito. So, to give you illustrations para lang ma-visualize natin yung application ng remedy na ito. So, if for example, A donated his land to be in writing, pero land ang dinodonate, okay, can be compelled the execution of a public instrument? Hindi, because the donation is void for not being in a public instrument. Again, the requirement of being in a public instrument in a donation of real property is for purposes of validity. So dahil void ang kontrata, walang remedy to require the other party to comply with the required formal requisites. So, second example, if A sold his land pero oral lang ang kanyang pagbebenta ng lupa, can be compelled A to execute a written instrument in order to make it enforceable? Hindi, because the contract of sale is unenforceable. Sabi natin dapat valid and enforceable in order to exercise the remedy that we have been talking about. So if for example, merong benta ng lupa pero in a private instrument, pwede na bang i-require ni BCA to execute a public instrument? Yes, because in this case, the contract is both valid and enforceable. No? Kaya available na yung remedy to execute a public instrument because the contract itself is valid and enforceable to begin with. Alright? So yan ang ating formal or forms of a contract. In relation to that, dinidiscuss din natin yung tinatawag nating remedy of reformation. To make it simple, reformation of instruments connote that there is an actual meeting of the minds between the parties. Meron kang written requisites. There is a meeting of the minds between the parties. Meron kang written instrument kung saan nakasulat supposedly ang inyong agreement, pero yung written instrument does not reflect the true intention of the parties. Kaya nga ang complete title ng remedy na ito ay Reformation of Instruments kasi ang binabago natin dito yung instrument mismo, no? To make it appear or to change the contents of the instruments to reflect the true intention or agreement of the parties. So, kailan ito pwede? If there is mutual mistake between the parties, dahil nagkamali sila ng nalagay doon sa kanilang instrument, or kung yung isang party was mistaken but the other one acted fraudulently kaya hindi nakareflect ang kanilang true agreement, then yung innocent party lang ang pwedeng manghingi ng reformation. Or if one party was mistaken and the other knew or believed that the instrument did not state the real agreement but concealed that fact from the former, again, the innocent party may ask for reformation. Or dahil dun sa typist or yung nag-prepare mismo ng document, there is ignorance, lack of skill, negligence, or bad faith on his part, kaya hindi na-reflect ng instrument ang true agreement, pwede ring magpa-reformation ang parties. Or if the two parties agree actually to a mortgage or a pledge of property, but it made it appear that the sale is a right that the contract is a sale with the right of repurchase. In which case, yan yung tinatawag nating equitable mortgage. Yung agreement nakasulat na it is a sale with the right of repurchase, but any of the circumstances that will give rise to the presumption of equitable mortgage is present. Such as, kunwari, there is a retention of the possession, merong continuous payment ng real property taxes, or expenses of preservation, yan yung mga magbibigay, will give rise to the presumption of equitable mortgage. Reformation is also the proper remedy. But take note that reformation will not be allowed with regards donations inter vivos when there is no condition imposed. Hindi yan pwedeng i-reform, no? Kasi si donor ang mismo nag-prepare presumably ng dokumento niyan. Or with regards wills, kasi ito patay na ang testator, no? Kaya hindi pwedeng sabihin na iba yung napag-usapan namin ng papa. Sabi niya, ibibigay niya sa akin ng lupang ito, you cannot have a reformation in relation to wills. Or when the original agreement itself is void, you cannot correct or you cannot cure the fact that the agreement is void via reformation. And lastly, by estoppel. If the party has already brought an action to enforce the instrument, he cannot later on claim, no, na mali yung nakalagay doon sa instrument because he has already initiated an action to enforce it. So kaya estop na siya to claim that the instrument does not reflect the true agreement of the parties. Now we go to the fundamental characteristics of a contract. There are 5 fundamental characteristics. Merong nag-send sa akin ito kahapon na gumawa siya ng sarili niyang acronym na pangalan niya, Marco. Ayan. Pero ikaw nang bahala. If you will notice, I don't actually use acronyms because I tend to forget the acronym itself. No, and yung acronym naman would be beneficial lang kung enumeration type ang questions. Nevertheless, the 5 fundamental characteristics will involve consensuality, autonomy or freedom to contract, or liberality to contract, liberty to contract rather, mutuality, obligatory force of contracts, and the principle of relativity or privity of contracts. These are all incorporated in all types of contracts, no? Lahat ito kasali. Kaya nga tinatawag silang fundamental characteristics kasi dapat lahat ng kontrata nandun sila, no? So first will be consensuality, 2 aspects, no? Number 1 is that contracts are generally consensual in character, that they are perfected by mere consent as a general rule, that there will be no required form, there is no required delivery or performance in order for a contract to be valid. Now, as long as there is consent as to the other essential elements, a contract is already perfected as a general rule. Now, the second aspect of consensuality is that consent is necessary in order for there to be a contract. Now, in one Supreme Court case, ang gobyerno, at the time na PLDT pa lang ang ating telephone company sa Pilipinas, wanted to have an interconnection agreement with PLDT. Basically, the government will, will tap the facilities of PLDT and use their facilities para magkaroon sila ng sarili nilang telephone services within the government, no? And then eventually they sue under contract. They sued under contract. Sabi ng Supreme Court, even the government cannot force anyone to enter into a contract. So since there was no consent coming from PLDT, there's no contract to speak of. No? Dun sa kaso na yan. Kasi nga consent will always be required in order for there to be a valid contract. Save for one exception, which is eminent domain, no? Na yun din ang ginamit eventually ng gobyerno. They exercise the power, the inherent power of eminent domain to force PLDT to enter into an interconnection agreement upon payment of just compensation. So yan, kahit walang consent ng other party because it is an inherent power of the state, wala tayong magagawa. So that's consensuality. Again, contracts are generally perfected by mere consent, and that consent will be necessary in order for a valid contract to exist. Second, essential or fundamental characteristics is autonomy or liberty to contract or freedom to contract. As a general rule, the parties may enter into any terms and conditions that they deem convenient as long as the stipulations that they will agree upon will not be contrary to law, morals, good customs, public order, or public policy. to give you some examples of stipulations that are deemed contrary to law. So dito, we presume that the law itself is part of the contract. No? Kaya you cannot stipulate against a specific prohibition by law. Some examples that you will find in the Civil Code will be waiver for future fraud, bawal yan. Or in a partnership, you cannot stipulate to exclude any partner from sharing in the profits or losses. The stipulation is called pactum leonina. Hindi yan pwede. Contrary to law din. Or in a contract of pledge or mortgage, the stipulation providing for automatic appropriation of the thing in case of non-performance of the obligation secured is pactum commissorium, which is also contrary to law. No? Or with regards a mortgage, specifically real estate mortgage lamang ito, walang pledge dyan. Real estate mortgage lamang. A stipulation prohibiting the owner of the mortgage property from alienating the same is also void. It is called pactum de non aliendo. So in all cases, the law itself prohibits the stipulation. Kaya hindi na pwedeng pag-agrihan niya ng parties because they will be considered contrary to law. Now, other examples in jurisprudence where the Supreme Court held the stipulation to be contrary to public policy will include a scholarship agreement. So dito sa kaso ni Cuy versus Arellano, si Cuy ay scholar ng Arellano University and there is a stipulation in the scholarship agreement na hindi siya pwedeng lumipat ng school. Na kung lilipat man siya ng school, babayaran niya lahat ng tuition na natipid niya at the time that he was a scholar of Arellano University. Of course, lumipat si Cuy. No? Kaya tayo nagkaroon ng kaso kasi kung hindi siya lumipat, wala tayong pag-uusapan. And the school wanted to enforce the contractual stipulation na pagbayarin siya ng tuition fee. Umabot ng Supreme Court ito, sabi ng Supreme Court, hindi yan pwede. No? Because by public policy, a scholarship should be granted based on merit and you cannot use it as a marketing strategy or propaganda na nire-retain mo lang yung mga estudyante. If they are entitled to it because of their credentials, then you should then they should be entitled to the benefits of the scholarship agreement without fear of paying for whatever they saved, no, because of the contractual stipulation. On the other hand, you have here Saura versus Nicko. Dito naman, si Saura at si Nicko ay nag-agree by stipulation within their political party na kung sinong matatalo sa kanila within the political party will not run in the national elections. Pero natalo yung isa, tumakbo, sabi ng Supreme Court, contrary to public policy din yung stipulation prohibiting somebody from exercising his political rights to be elected. No? Because on the other hand, you are also depriving the electorate of their constitutionally protected right to choose whoever they want in a public office. No? Kaya dineclare yung stipulation as contrary to public policy. Sa morals, it was used to reduce interest rate in an obligation. In one Supreme Court case na umabot ng 50 to 75% yung interest na binabayaran, it was reduced by the Supreme Court on the ground that it was already contrary to morals. The stipulation would be contrary to morals already. Now, mutuality would entail that both parties must be bound by the contract itself. On the second aspect of it, the validity or the compliance of the contract cannot be left to the will of one party. Kaya nga hindi ka nagkakaroon ng potestative conditions, no? Kasi the validity will be dependent on one party, or with regards escalation clauses that are one-sided. An escalation clause is a provision in a contract that may provide for an increase or decrease in the cost or consideration. But it can be valid naman. No? An escalation clause can be valid if it is dependent on something that is independent of the parties, or the trigger will be independent of the parties themselves. So for example, sa contract of lease, pwedeng mag-increase ang rental payments kung kunwari tumaas ang dollar-peso exchange rate. No, valid yan kasi ang nagiging basis niya naman ay something independent of the minds of the parties, which is the foreign exchange rate. No? Pero if it is dependent on one party only, such as in one case, no, yung Spouses Florendo versus PS Bank. In that case, PS Bank can unilaterally increase the interest rate in the stipulation or in the contract of loan. It was declared to be void by the Supreme Court. No, because it violates the principle of mutuality, because again, the compliance to the obligation in the contract cannot be left to the will of one of the parties. It will violate the principle of mutuality. No? So an escalation clause to be considered valid must be based on something that is independent of the will of the parties. Now, this principle will be based on the essential equality between the parties, since it would be unfair for one of them to be bound by the contract and the other one to be freely decide whether he is bound by the contract or not. Kaya kung kunwari, pumasok ka ng kontrata, tapos naisip mo bigla na parang hindi ako kikita sa kontrata na ito because some certain circumstances changed, which could have been foreseeable. In that case, you cannot use that as a valid excuse to relieve yourself of your liability under the contract because of the principle of mutuality. Obligatory force would connote that a contract between the parties will have the force of law between them, in the sense that non-compliance with the obligation in the contract would make it as if there was non-compliance with the law itself. Kaya it will require that the parties must comply with their obligations in a contract in good faith. So, yun ang ating 4 fundamental characteristics. Itong relativity lang yung medyo madami. So, relativity or privity of contracts will have 2 concepts of exceptions. So, initially, relativity of or privity of contracts as a general rule would connote that the contract will take effect only between the parties, their assigns and heirs, which are referred to as privies. Kaya nga ang tawag din natin ay privity of contracts. Kaya sa general rule, hindi apektado ang mga third persons. Kasi nga ang pwede lang maapektuhan ng kontrata kung sino ang pumasok sa kontrata na yan, or including the assigns or the heirs of the parties themselves. But by way of exception, hindi or that the contract will not extend to the assigns or the heirs of the parties when the obligations under the contract are non-transmissible, such as when the nature itself of the obligation is that it is non-transmissible. So when the qualifications, for example, were what do you call this? Considered before the contract was constituted. So nag-hire ka ng kakanta sa kasal mo, Kunwari gusto mo si Moira na merong malaking face shield. So hindi pwedeng magkaroon ng substitute because or na hindi niya pwedeng ipamana or mag-assign sa ibang tao ng gagawa ng obligation under the contract because the qualifications were considered in constituting the contract itself. Or by stipulation. For example, the right to sublease is allowed by law, but you can prohibit the right to sublease by stipulation of the parties. Kaya by stipulation, nagiging non-transmissible yung obligation. Or by provision of law. So if for example, a usufructuary, pag namatay siya, hindi niya pwedeng ipamana ang kanyang usufruct over a property because by law, it is non-transmissible. It will automatically go back to the owner of the naked title. Hindi pwedeng ipamana. Except, of course, if there is stipulation to the contrary. Now, the second aspect as to relativity, sabi nga natin as a general rule, it will not affect third parties. Hindi pwedeng maapektuhan ng mga third parties. They are not bound by the contract. They cannot enforce or hindi rin sila pwedeng makialam sa kontrata to which they are not parties to. There are 4 exceptions, however, provided for by law. Number 1 is when third parties may be bound by the contract. Kasama dito yung mga contract establishing status. Dali. Status. So kung kunwari, may contract of marriage between 2 persons, sila lang talaga ang affected ng contract of marriage na yan, but all the people in the world are likewise affected in the sense na hindi mo pwedeng sulutin. Kasi bound ka rin by their contract of marriage. Or kung kunwari yung mga real property or real estate mortgage that is registered. So even if you are not a party to the contract of marriage, you may be bound by the mortgage because it was registered. So yan yung mga types where third parties may still be bound even if they are not parties to the contract itself. Or when the creditor may initiate an action against the contracting parties Dito papasok yung tinatawag nating aksyon polyana in a contract made by the debtor to defraud the creditor, or an aksyon direkta. So, aksyon direkta muna, bigyan natin ng example. Kunwari ito si lessor, tapos ito ang kanyang lessee. So, the contract of lease is between the two of them only. Ito namang si lessee, may contract of sublease with the sublessee. So, ang contract of sublease will be between the lessee and the sublessee only. If the lessee does not pay the lessor, the law allows the lessor to directly collect from the sublessee. That is action directa. No? Even if the lessor is not a party to the sublease, the law grants the lessor a remedy to collect directly from the sublessee, but only to the extent of the liability of the sublessee or the liability of the lessee, whichever is lesser, no, in amount. In aksyon polyana, if for example, ito si debtor may utang kay creditor na 1 million pesos, tapos si debtor entered into a contract of sale to sell his only remaining property to defraud C, para maitago kay C yung land. No? In this case, kahit ang contract of sale ay between D and X lamang, pwedeng makialam si C dyan sa kontrata na yan via action polyana to rescind the contract entered into by the debtor to defraud the creditor. The creditor will be allowed to interfere and rescind that contract. So kahit third party siya to the contract of sale, inaalaw siya ng batas na makialam. Or when third persons may be liable under the contract, dito papasok yung tinatawag nating malicious interferor. Nakialam, no, yung isang tao, yung third party, kaya nagkaroon ng breach of contract. So kunwari, in one bar exam question, kunwari itong si X at si Y entered into a contract of employment for a 2-year contract of employment. So sila lang ang parties to the contract na yan. Pumasok itong si Z, sabi niya kay Y, doblehin ko lahat ng offer sa'yo ni X. No, kaya si Y, binreach niya ang kanyang employment contract. In this case, X may also recover damages from Z. No, but Z cannot be made more liable than Y because Y remains to be the party who breached his contractual obligation. But since Z is a malicious interferer, inaalaw ng batas na pwede rin siyang maging liable because of his interference. Or when third persons may be benefited by a contract to which they are not parties to, dito pumapasok yung tinatawag nating stipulation for autrui. So other than incidental matters, a third person who may be benefited by a contract may enforce the same once he already communicated his acceptance of the benefit under the contract. No? So kahit hindi siya party to the contract, magbe-benefit din siya. So those are our exceptions to the rule on privity or relativity, where third parties may be affected, may initiate an action, may be liable, or may benefit under the contract even if they are not parties thereto. And now we go to the rules on interpretation of contracts. As a general rule, hindi natin ginagamit ang rules on construction or interpretation if the contract itself is clear and have no doubt with regards to the intention of the parties. Whatever is literally indicated in the contract will be controlling at yun ang ating susundin. Kaya ginagamit lang natin ang rules na ito kung sakaling nagkaroon ng doubt or ambiguity in the provisions of the contract itself, no? Such as when the words appear to be contrary to the intention, in which case intention ng ating magiging primordial consideration. Laging intention ng mga parties ang dapat na masusunod. Now, specifically, yan, in order to judge the intention of the parties, pwede nating gamiting basis yung kanilang contemporaneous or subsequent acts. Hindi ako makapagsulat. Ayan. They can be considered, such as in one Supreme Court case. Ayan. So in one Supreme Court case, sabi nung isang contracting party, dineliver ko nga sa yung motor as payment. Dasyon and pago daw ang kanilang kontrata. Pero deed of assignment yung kanyang in-execute na contract. Tapos, after niyang i-deliver, nagkaroon pa siya ng mga installment payments. Tapos nagkaroon pa ng, what do you call this? Yes, nagkaroon ng installment payments. Sabi ng Supreme Court, the contemporaneous or subsequent acts of paying the installment negates the premise of adasyon and pago. Kasi kung dinasyon and pago mo talaga yung motor, kaya mo yan dineliver sa iyong creditor, ibig sabihin payment na. Bakit ka pa nagkaroon ng installment payments thereafter? Kaya the Supreme Court agreed with the creditor that because of the contemporaneous and subsequent acts of the parties, the delivery of the motorcycle actually amounts to a security, particularly pledged lamang, to secure the installment obligations of the debtor. Okay, so yan. Kino-consider din natin in interpreting contracts. Specific rules. So however general the terms may be that was used in the contract, they will still be interpreted to mean or comprehend things that are distinct, and cases that may be different from those which the parties intended to agree. So if, for example, si S nagbenta ng house in lot kay B, tas nakalagay included all furniture sa loob ng bahay. Generic lang ang terms na all furniture. Alam natin yan. Ang ibig sabihin, lahat kasama. No? But the TV, as it turns out, does not actually belong to X na hiniram lang niya sa ibang tao. So kasama ba yung TV set sa kanilang contract of sale? Hindi. Because even though the term all is considered generic, we will consider it distinctly in the case itself as to contemplate only the furnitures that will be belonging to the seller. Kaya yung mga hindi kanya, hindi kasama sa kanyang binenta. Second, if there are several meanings with regards to the words that are being used in the contract, we will interpret them in a way that will be most adequate to render the contract effectual. So if, for example, si W, asawa ni H, nagbenta ng her house, it turns out dalawa ang bahay niya. Meron siyang in-inherit na bahay, kaya exclusive property niya, at meron namang conjugal house, which is the family home of the spouses. In this case, we will interpret her house to mean her exclusive house para lang maging valid. No? Kasi if we are going to interpret it to mean the conjugal house where the family home is constituted, it may be regarded as void for lack of the husband's consent under the family code. Okay? And if there are various stipulations in a contract, they will be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Kaya minsan nagkakaroon din tayo ng references to the other provisions of the contract to understand what the other provisions would mean. We can also consider the different significations of the words that are being used. They will be understood to that which is most in keeping with the nature and object of the contract. And we can also utilize the usage or customs of the place in determining how to interpret the ambiguous words that we will find in the contract itself. And when the interpretation of obscure words, we will not interpret it in favor of the one who caused the obscurity. In fact, ito lang naapektuhan ng contract of adhesion. In the concept of consensuality, sabi natin kailangan may consent. In a contract of adhesion, one party prepares all the terms and conditions already of the contract and the other party merely adheres. Na it's a take it or leave it situation. Na kung hindi ka nag-agree sa mga stipulation, di wag mong pirmahan. Pero kung pinirmahan mo, ang presumption nag-agree ka. And these are valid contracts. It will not affect the validity of the contract nor the validity of the stipulation. But in case there is ambiguity, i-apply natin ang rule na ito. No? The ambiguity will be interpreted in favor of the one who merely adhered. Kasi nga, yung nag-prepare, siya na nga yung nag-cause ng obscurity, syempre hindi na natin i-interpret in his favor yung stipulation na yan. Now, when there is no specific rule that can be applied, and ambiguity pertains only to incidental circumstances, then it will depend whether the contract is onerous or gratuitous. If the contract is onerous or gratuitous in character, we will interpret using the least transmission of rights as the rule. But if it is onerous, it will be greatest reciprocity of interest. So if, for example, in one agreement, sabi ni X kay Y, I will give to you my car. Tapos there was ambiguity in the contract kung kasama ba yung stereo. So if the contract is a donation, kung donation itong pagbibigay ng kotse, so gratuitous, we will interpret that the stereo will belong to X. Kasi least transmission of rights ang gagamitin natin kung donation. Pero kung ito ay sale, so being onerous, then it will be belonging to Y. Because in that case, we will interpret it using the greatest reciprocity of interests as our rule. But take note, These rules will apply only kung wala ka nang ma-apply na specific rule. At pangalawa, it pertains only to incidental circumstances. Kasi if the ambiguity pertains to the principal object itself, the contract will be void. No? Kasi walang object which is an essential element of a contract. So kung sinabing, I will give you one of my 5 cars, pero hindi sinabi kung aling kotse and it pertains to the actual principal object, then the contract itself will be void already. Kasi hindi incidental ang ating pinag-uusapan. And lastly, we go to defective contracts. Kapag nagtanong as to the level of validity, ito na rin ang pagkakasunod-sunod yan. The most valid will be valid and binding. The least defective is rescissible. Second least defective is voidable, then unenforceable, and the most defective will be void contracts. Rescissible contracts are very specific. Lilima lamang ito. And yung first two natin pertains to lesion. Lesion pertains to economic damage. So, and it pertains specifically only to the properties of wards na binenta ng guardian or property ng absentee na binenta ng representative. Kung binigyan ka sa choices ng agent ang nagbenta tas nagkaroon ng lesion, hindi yan rescissible. Kasi specific lang tayo sa property ng ward at sa property lamang ng absentee. So kung kunwari, 1 million ang fair market value ng property ni ward, binenta yan ni guardian, let's say for 600,000 lamang, magkakaroon dito ng lesion na 400,000. Ito yung lesion mo, which divided by the actual value will be 40%. So dahil more than 1/4, magiging rescissible na ang kontrata at the instance of the ward. The third rescissible contract will be those in fraud of creditors. Dito papasok yung tinatawag nating aksyon polyana. So in order for the creditor to rescind the contract entered into by the debtor to defraud him, no, kasi nga rescissible contract yan, aksyon polyana ang kanyang available remedy. Or those which are under litigation, no, without the consent of the other litigating party or that of the court. Stated otherwise, kung under litigation man ang object pero meron namang approval ng court or consent ng other party, then valid pa rin. No? Hindi magiging rescissible. Dapat without knowledge or approval of the court or litigants. And lastly, those that may be provided for by law, specifically to be rescissible. Some of those provided for by law to be rescissible will include the rights of an unpaid seller. No? So yan yung right of rescission ng unpaid seller. Kung sakaling, what do you call this? There's been no payment for an unreasonable length of time or there is a stipulation granting the right of rescission. Or when the thing deteriorates with the fault of the debtor, ito yung mga rules natin on loss, deterioration, and improvement. When it deteriorates with the fault of the debtor, one of the options of the creditor is to rescind the obligation. Ito yung may obligation to deliver a specific thing subject to a suspensive condition or term. Or lesion of at least 1/4 in relation to partition. Rescission will also be a remedy available to the co-owner who suffers the lesion. Or in a sale of real estate, where the deficiency in the area delivered is at least 1/10, or that the buyer would not have entered into the contract knowing of the deficiency. Rescission will be also an available remedy provided for by law. So rescission as a remedy is subsidiary in character. Take note that we are talking about here rescission in rescissible contracts and not necessarily resolution. No, which is also rescission in reciprocal obligations. Kasi dito sa reciprocal obligations, basta meron ng breach, no, or substantial non-performance, agad-agad pwede ka nang mag-rescind or resolve nung obligation. No? When one party is ready and the other one is not. But when we talk about rescission as a remedy in rescissible contracts, we call it a subsidiary remedy, and it will be allowed only when there are no other means to recover on the part of the injured party. Kaya nga tawag din dito ay remedy of last resort. Kaya din nagiging least defective ang rescissible contracts. Rescission can only be to the extent necessary to cover the damages suffered, and restitution will be the generic effect or mutual restitution where both parties will be required to return whatever it is that they receive under the contract. And it can be carried out only when one party who demands for rescission can return whatever he may be obligated to restore. Kung hindi mo na kayang ibalik yung na-receive mo under the contract, then hindi ka rin pwedeng manghingi ng rescission. Kasi nga, mutual restitution ang magiging generic effect niya dapat. And rescission shall not take place when the things are in the possession of a third person who did not act in bad faith. Kasama na dyan yung mga innocent purchaser for value because they will have valid possession and ownership of the thing. Ang magiging remedy mo na lang is to ask for damages. No? But you cannot physically recover the object anymore. And yun nga yung sabi natin kanina, even if the thing is under litigation but there was approval by the courts, even the sale by guardians, rescission is not an available remedy. Okay? Now, rescission, prescriptive period for rescission will be 4 years kung fraud ang iyong ground discovery, no, for yung mga in-fraud of creditors. But in all other cases, 4 years, like in guardianship, it will be applicable once the guardianship ceases or for absentees once their last known address or their domicile is already known. Doon magsisimula ang bilang. But when we talk about 4 years counted from discovery in relation to fraud, pero real property ito that is registered, no? Sabi ng Supreme Court, ang bilang natin ng 4 years will be from the time of registration. Because registration in the Registry of Deeds constitutes notice to the entire world. No? Kaya yan, dapat doon ang bilang natin ng 4 years. In the case of HSBC versus Pauli. And voidable contracts. There are generically 2 types of voidable contracts only. No? Those where one of the parties is incapable of giving consent, yan yung may defects sa kanilang legal capacity or capacity to act, such as the minors, insane, no, or those who are not able to read and write, that is deaf-mute, okay, and those whose consents are vitiated by any of the vices of consent that we have already mentioned. If we are going to be technical about it, may third pa dito, the drunks and those who were hypnotized. Kasama rin yan. No? Magiging voidable din ang kontrata on the ground of drunkenness or hypnosis. Now, with regards to the prescriptive period for annulment, 4 years ito. Iba-iba lang ang bilangan natin kung kailan magsisimula. If it is those affecting voluntariness in giving consent, the 4 years will be counted from the time the defect ceases. Kung ikaw ay ginugulpe, kung kailan ka tinapos gulpihin, tsaka lang magsisimula yung bilang ng 4 years mo. With regards those affecting intelligence, we count the 4 years from discovery. No? Kaya mistake or fraud. With regards those who are the ground for being voidable will be with regards to the legal capacity or capacity to act then when the guardianship ceases. So for minors, pagdating nila ng 18 years old, tsaka lang magsisimula yung bilang natin ng 4 years. Alright? Now, there is, however, ratification. Hindi naman ibig sabihin laging annulment when we talk about voidable contracts. You can ratify an originally voidable contract. And ratification will extinguish the action to annul a voidable contract because it cleanses the contract of any defect, no, that they may be caused by the vitiation of consent or the lack of legal capacity. Ratification may be effected by the guardian of an incapacitated person and will not require the conformity of the other contracting party. So kung kunwari lack of legal capacity, the other one is capable of giving consent naman, hindi kailangan na i-approve pa niya ang ratification. It cleanses, as we mentioned, the contract from any of its defects, kaya nawawala na ang remedy of annulment kapag na-ratify na ang voidable contract. And it can be done either expressly or impliedly. Expressly, talagang merong tacit ratification na despite the defect previously, it will be cured already by your ratification, or it can be implied when you continuously receive the benefits of the contract. So kunwari, minor, yung lessor at the time the contract of lease was entered into, pero upon reaching 18 years old, dire-diretso niya lang tinatanggap yung mga upa. No? In that case, that can be implied ratification of the voidable contract already. Annulment, on the other hand, will be the remedy that will make the voidable contract non-existing from the very beginning, as if no contract was entered into. Kaya nga the only one who can invoke annulment will be the injured party, not the creditors, not the other party who is capable of giving consent or the one who vitiated the consent of the other. Hindi pwede, no? Yung injured party lamang. And in case of minority, the minor misrepresents his age, magkakaroon ng concept of estopel, in which case it will be as if the minor actually gave valid consent. Ang premise dito is that if the minor was aware of his lack of legal capacity to enter into a contract and made a misrepresentation therefore, and the other party relied on it, it will be better served na maging bound na lang siya ng kontrata on the premise of estopel. No? Kasi nga, kaya niya palang manloko, di ibig sabihin, alam niya na yung pinapasok niya. And those who are incapacitated cannot allege the incapacity of the other party with whom they contracted with, nor those who exerted any of the vices of consent. Hindi nila pwede yung i-invoke. Kasi nga, only the injured party can invoke annulment as an available remedy. So what will be the effects when annulment is a remedy taken into account? Generally, the parties will be required to have mutual restitution, no? To give back whatever they receive under the contract. Kaya nga, as a general rule din, kapag nawala na yung object that you are required to return, generally you cannot ask for annulment anymore, no? Or nawawala din ang remedy ng annulment, parang sa rescission. Except, no, with regards minors or those or the reason why the contract is voidable is because of incapacity. So yung minors, insane, because they are not obliged to return whatever they receive under the voidable contract, except insofar that they may have benefited therefrom. No? Kasi kung kunwari, insane or demented person, no, so nawala sa isip niya kung saan napunta kunwari yung na-receive niya under the contract, he or she is not required to return that. Ang presumption ng batas, hindi siya pipilitin na hanapin, no? Kasi nga, in the first place, why did you enter into a contract with an insane or demented person with the risk na pwede niyang mawala yung matatanggap niya under the contract? No? Now, with regards to obligations to render some service, of course, hindi na pwedeng bawiin yung serbisyo, kaya only the value will be the basis for computing damages. Unenforceable contracts, tatlong klase lang ito, no? Papasok yung unauthorized, those that are entered into without the authority of the person who is supposedly represented. So kunwari, yung tatay may-ari ng cellphone, yung anak binenta yung cellphone na walang authority, it will be unenforceable as to the principal, which is the tatay. Kasi walang authority. Second form of unenforceable contracts will be those that did not comply with the statute of frauds. Yan yung in-enumerate natin earlier na mga transactions, 6 of them, which is an exclusive list already. And third will be when both parties are incapacitated. So hindi naman komplikado yung first and third. No? Normally yung unenforceable contracts would actually relate to those falling under the statute of frauds. So to expound lang on the rules concerning statute of frauds, it will apply only to executory contracts. Hindi ito mag-a-apply if the contract has been already partially or completely executed. Ang premise kasi dito is that you cannot prove the existence of the contract by oral testimony. No? But if there was partial or complete performance of the contract already, you can prove the performance by oral testimony. Kaya hindi na mag-a-apply yung statute of frauds if there has been some partial or complete performance of the obligation already. The list is exclusive. Sabi natin, kung wala sa listahan, hindi mako-cover. Kaya nga, lease of car, kahit more than 1 year, hindi covered ng statute of frauds. The defense of statute of frauds may be waived. In fact, no, you can actually waive that impliedly because you were not able to object to the presentation of oral testimony. If you fail to object in the presentation of oral testimony, that will be an implied waiver of the defense of statute of frauds already. But it is personal in the sense na hindi mo pwede itong ipasa sa ibang tao. No, it will only be available to the party to the contract that did not comply with the statute of frauds. And yan nga yung sinabi natin kanina, if oral evidence is presented in the trial to prove the existence of the contract but you did not object to the presentation of oral evidence, that will be deemed a waiver already. And the contract originally unenforceable will be taken out of the operations of the statute of frauds and will become enforceable despite the fact that it was not in writing. And lastly, we have void contracts. So literally, void contracts are those where any one of the essential elements of a contract are not present. Mukha lang marami yung listahan na ito, pero makikita nyo yung isa sa tatlong essential elements nawawala or may defect. So una, the cause, object, or purpose is contrary to law, morals, good customs, or public policy. Or with regards consent, when it is absolutely simulated. Sabi natin kanina, yan yung walang intention to be bound by a contract. Ay, lobat na yung laptop ko. Or when the cause or object of the contract is non-existing. Again, nawawala ang cause or object, which is an essential element of a contract. Or when the object is outside the commerce of man, or when it contemplates an impossible service. So, di ba, sa object or consideration, sa object na naman siya papasok. Or when the intention of the parties with regards the principal object cannot be ascertained. Kanina, kung incidental matter lang, pwedeng least transmission or greatest reciprocity, ang ambiguity, no, i-solve natin through that interpretation rules. But if it pertains to the principal object, the contract will be void. Or those that may be specifically provided for by law. You will notice na again, sa void contracts, either ang defect or nawawala or illegal kasi is the object, cause or consideration or walang consent. So basta mukha lang siyang mahaba pero it all pertains to the three essential elements of a contract. And that concludes our discussion. For lack of material time, sana kahit paano we made it as comprehensive as we can given the very limited time that we have to discuss the law on contracts. So maraming salamat ulit sa NFJPIA for having me and for your patience na kailangan nating i-move yung webinar today instead of last week. But thank you for having me. And ongoing pa rin po ang ating enrollment for Rio October 2021 and open na rin po ang enrollment for May 2022. Maraming salamat po yung mga nanonood sa live. I hope you stay safe. God bless po and keep safe. Yan. Maraming salamat. Thank you very much.